Yeah. Good evening, friends. And we are sorry that the session has been delayed because of some technical glitches. Be that as it may, once you have a good speaker like Justice K.T.Sankaran and the session being introduced by himself, who is a known resource person and whose book is likely to be released shortly, I will ask Shyam Padman, a good friend and a brother, to introduce the topic, who has joined us after a lot of days and persuasion. We will take his session also one day. But be that as it may, they said that good things always take time. Over to you, Shyam.
Thank you, because before I get on with my pleasant task, let me congratulate you for carrying on this good work. It's really, really wonderful that you are continuing with it so that it will benefit the legal fraternity and also the justice dispensation machinery. Now, my task is very interesting because for all of you, he might be Justice K.T.Sankaran, but for me, is Shankaratan, my elder brother in this profession now, whom I was fortunate to associate from the early days when I entered the profession under the tutelage of my senior Sri T.P. Arvindhakshan, a phenomenally successful lawyer whose knowledge and erudition in law could carry any day, could get any case through any tough judge. Then as a judge, he was well balanced and a wonderful judge. And then his stint in the Judicial Academy, and in fact, during which period I was exposed to different conferences, classes, etc., wherein I had the privilege to take classes and things like that. And the way in which the Judicial Academy rose or reached such heights during his stewardship is wonderful. And then as a professor, as a teacher in different colleges, especially Nuals, etc., he left an indelible mark in the sense like even today, I'm sure that the students are benefiting with his different classes on the Code of Civil Procedure and they cherish his classes because the way in which he is Is there any disruption? I'm sorry.
No, it's fine. It's fine.
Okay. The way in which the classes were being taken, all I'd say, add to his and you can. I'm sure that this platform has been experienced, exposed to the classes on earlier occasions as well. And today, I'm sure that it will be no exception because it will be a wonderful Wednesday evening, well spent, and we'll all go back home knowing the nuances of representative suit. I think that being the topic today, because it's very interesting because many of us are not very thorough or aware about how it can be. Is it just for the plaintiff side? Is it for the defendant side? Or is it available? And for that matter, it is more importance because even the new generation laws like Consumer Protection Act, etc., are now saying, or rather the new statute of 2019 says that order one rule principles are applicable. So without wasting any time, and I don't want you to be kept away from the wonderful topic and the wonderful speaker today, let me not just introduce, welcome and request Shankaratan, Justice K.T.Sankaran sir, to kindly get on with the expose us to the nuances of the representative suit, order one rule especially. Thank you very much for the privilege. It was indeed a privilege to me today.
Just a minute, Mr. Sharon, you have become the host. Kindly make us. Yeah, thank you. Over to you, sir.
Thank you, Mr. Vikas and Mr. Shyam Padman. Shyam Padman is a close friend of mine, and at the Kerala Judicial Academy 3 days programs, I think 2 such programs were done by him and his team, and we gave him full freedom to select the topics, select the sub-subjects, and do it, have his own resource persons, and do it wonderfully. Thank you both. And today's subject, see, I think now it is 9:25. I'll finish it at 10:30. 10:30 is our allotted time. I'll finish it.
So just camera placement at the center. You can just push it. Thank you.
Now it is all right.
The
Perfect.
photograph up till the chest. Yeah, perfect.
Perfect. So when I sit back, it will be yes. Our subject is representative suits. The exact provision in the Code of Civil Procedure dealing with representative suits is Order 1, Rule 8. Order 1, Rule 8. And there are some connected provisions to be seen along with this. One is explanation 6 to section 11. Section 11 is, as you know, res judicata. Explanation 6 there too. And also the connected provisions are Order 23, Rule 1.1, Rule 1.3, and Rule 3 that we will get when we read it. Now let us see, there are 6 subsections and an explanation to Order 1, Rule 8. Order 1, Rule 8, representative suits. What is exactly the term representative suit? By an example, I will elucidate. See, there is a public pathway. Hundreds of people are using that pathway. It has got a particular width. It goes from one village to the other. On either side of the pathway, there are several houses. And in our state, it is houses means everywhere it is houses. Unlike the other states, there are several houses, several compounds. And every person residing nearby uses the pathway to go to the next village. So it is up to their interest that the pathway is in a good condition. It is not, its width is not reduced. But some people or several people are interested in encroaching upon portions of the pathway. So it becomes necessary to maintain the width of the pathway throughout and also to restrain them from doing so. Suppose it is 1 or 2 persons, they can file the suit. Who are all the parties to the suit? Who are all the plaintiffs? Who are all the defendants? CPC provides it. Who have cause of action? They will be parties to the suit. And who are entitled to get the relief and against whom the relief will be obtained, they are the defendants. But when there are numerous persons, it is not easy to get all of them. Many of them, one may not know, or two or more of them may not know. So it is not possible to have their signature, their joining in the plate. And therefore, 1 or 2 persons, or 2 or more of them, or even 1 person can file the suit representing the whole body of persons having the same interest in the subject matter, and file the suit against the person or persons who are inclined to encroach upon the property. And the plaintiff is set to represent all the persons who are similarly situated as him, who have similar interests. And there is a procedure for it. And if that procedure is complied with, he has to continue the suit, conduct the suit as a dutiful plaintiff with due diligence, bona fides, with no collusion or fraud, and complete. Sometimes there may be several persons who are inclined to deny your right. Many of them not known to you. There may be innumerable. So in the same suit, those persons can be represented by 1 or 2 or more named persons. So plaintiffs can be in a representative capacity. So also defendants can be in a representative capacity. So 1 person may institute a suit representing the whole body of persons who are having similar interest. And the suit can be filed against 1 person, he representing the whole body of persons who are having similar interest as that of the defendant. Both are possible. being sued, being the plaintiff, or being the defendant. Sue or being sued, both in a representative capacity. Some suit, the plaintiffs may be in a representative capacity and the defendant, the named defendant. Sometimes the plaintiff may be one named person, your nominee party, and the defendant may be in a representative capacity. In some cases, both the plaintiff and the defendant may be having representative capacity. The procedure has to be followed. And then when such a suit is filed, the plaintiff has to conduct the suit in a diligent manner. He cannot withdraw, he cannot compromise, he cannot abandon the suit without the permission, without following the procedure. And if one and the plaintiff, suppose there is one plaintiff and he is colluding with the defendants, another person who is having same interest can come on record. He can make an application and get himself as a plaintiff. Or a person already there can get the plaintiff transposed, even having different interests. That also can be possible. Everything is possible so that a decision binding on all will be obtained and there will be a permanent solution to all. What is the object of Order 1 Rule 8? Object of Order 1 Rule 8: to facilitate the decision of questions in which a large body of persons are interested without recourse to the ordinary procedure. In cases where common right or interest of a community or members of an association or large sections is involved, there will be insuperable practical difficulty in the institution of suits under the ordinary procedure, where each individual has to maintain an action by a separate suit. To avoid numerous suits being filed for decision of a common question, Order 1 Rule 8 has become to be enacted. It is an exception to the general rule. Order 1 Rule 8 is an exception to the general rule that all persons interested in a suit ought to be made parties there. Order 1, Order 2, Order 4, all those things, orders in the CPC provide for pleadings, how the plaintiffs may be joined, how the defendants may be joined, how cause of action should be joined, etc., etc. Detailed procedure is there. In one case, an Andhra Pradesh case, only one High Court judgment I propose to cite. There are several High Court judgments. I am citing only Supreme Court judgments. But in one High Court judgment, AIR 1957, Andhra Pradesh, 964, L. Ramasheshaya versus M. Ramaya. There is a beautiful paragraph. Order 1 Rule 8 Civil Procedure Code, an enabling provision, is an enabling provision and does not compel anyone to represent many if by himself he has a right to suit. The pathway question. There are several plaintiffs who are also interested in protecting the pathway. I am the plaintiff. I need not bother to institute a suit representing all. I can file the suit on my own because I have got a cause of action. But I can do the other way also. Then it will be binding on all. It will be beneficial to all. This rule does not vest a right of a suit in a person. And if he by himself has no right to sue, he cannot proceed to sue on behalf of others by invoking the aid of Order 1 Rule 8 CPC. That means a person who is going to represent the suit in the suit several persons, he must have a right to file a suit. At the same time, Order 1 Rule 8 CPC does not debar a member of the village community from maintaining a suit on his own right in respect of a wrong done to him, though the act complained of may also be injurious to some other villagers. Then another principle is that Order 1 Rule 8 as such may not apply to suits under Section 92 of the Code of Civil Procedure. Then explanation 6 to Section 11 that applies to suits in a representative capacity as well. And then let us see the wording and also the ingredients of Order 1 Rule 8. Because without that, it is not possible to explain all aspects. I will read subsection 1. Where there are numerous persons having the same interest in one suit. Clause A. One or more of such persons may, with the permission of the court, sue or be sued, or may defend such suit on behalf of or for the benefit of all persons so interested. Clause B. The court may direct that one or more of such persons may sue or be sued and may defend such suit on behalf of or for the benefit of all persons so interested. What is it? This clause B was introduced in 1976. And before 1976, there were only 2 subsections which contained the present clause A of subsection 1 and also subsection 3. All other things were introduced in 1976. So what is clause B? Clause B. Court may also direct one or more such persons. They may file a suit on their own. Court may direct also. That is a new provision. What is the meaning of it? Clause B of subsection 1 is new, empowering the court to direct that one or more of such persons may sue or be sued or may defend such suit for and on behalf of all persons so interested. That is having the same interest in the subject matter of suit. A case for giving such a direction can arise only when permission under clause A is not applied for and obtained. The court comes to know that the plaintiff filed a suit on his own. The court knows that there are several persons. Several persons may file an application for impleading. I am also interested, I may be impleaded. Such applications may come. Then the court may know from the defense, all those things, that there are several persons involved who are having common interests, either as that of the plaintiffs or as that of the defendants. The court may direct anyone to act in a representative capacity. That is clause B, introduced in 1976. Now, subsection 2. We'll complete reading this, then we'll go to some of the decisions. The court shall, in every case where permission or direction is given under sub-rule 1. One is permitted. I file the suit, not only on my behalf, on behalf of several other persons, with the permission of the court. Their permission of the court is required. The other is, the court directs me to represent all other persons or somebody else to represent. The court shall, in every case where a permission or direction is given under sub-rule 1 and the plaintiff's expense, give notice of the institution of the suit to all persons so interested, either by personal service or by reason of the number of persons or other cause. Such service is not reasonably practicable by public advertisement as the court in each case may direct. Suppose there are thousands of persons who are having same interest as that of the defendant, and the defendant is being sued in a representative capacity. The court may direct notice. How? If it is not possible to serve on all of them, the court may say in public advertisement, newspapers, in such other manner as the court thinks fit. What is the meaning of the word numerous? It was held that it is not synonymous with the word numberless or innumerable. The meaning is not innumerable, numerous. It is not numberless. Each case must depend on its own facts. This was held. Now, this advertisement or such personal service as the court directs is required. Permission or direction, then at the expense of the plaintiff, this has to be done. So that what is the principle behind it? That when a suit is either decreed or dismissed or the defense upheld or the plaintiff's case upheld, it is beneficial to all such persons who are having same interest as that of the plaintiff. So also it is binding on all persons who are having same interest. So they must know that such a suit is going on. Therefore, public notice is given in such manner as the court thinks fit, so that they are deemed to know. They are deemed to know that about it, and people will know about it. They can come on record if necessary, or they can watch the proceeding whether the plaintiff is doing it diligently or not. Their interests are also being protected or not, etc. But keeping them in dark, a plaintiff cannot represent others having the same interest. That is why this publication and notice is provided in sub-rule 2. Sub-rule 3, any person on whose behalf or for whose benefit a suit is instituted or defended under sub-rule 1 may apply to the court to be made a party to such suit. See the example which I gave, village party. There are hundreds of persons who are beneficiaries. One person files a suit in a representative capacity on behalf of others as well. And several persons approach the court. We also may be added as parties so that we will be knowing what is happening in the court. And we will be also entitled to help the plaintiff in doing so. We will watch the proceedings and we will produce such evidence as are necessary. Court may permit. Then 4. No part of the claim in such suit shall be abandoned under sub-rule 1, and no such suit shall be withdrawn under sub-rule 3 of Rule 1 of Order 23. And no agreement, compromise, or satisfaction shall be recorded in any such suit under Rule 3 of that order. That order means Order 23. Unless the court has given at the plaintiff's expense notice to all persons so interested in the manner specified in sub-rule 2. So what is Order 23 Rules 1 and sub-rule 1.1 and 1.3? Order 23 Rule 1 provides for abandonment of suit and withdrawal of suit. Abandonment, a plaintiff, suppose he is the only person interested, there is no representative suit, etc. I am having a right, I file a suit, I can abandon the suit, nobody can question it. But I cannot file a suit thereafter, another suit thereafter. Once abandoned. I can withdraw the suit. There may be various reasons which are provided in Rule 3, sub-rule 3 of Order 23 Rule 1. Court may permit such withdrawal, and with the permission of the court, another suit can be filed. It can be withdrawn with permission or without permission. If without permission the suit is withdrawn, he cannot file a suit on the same subject matter again. If it is withdrawn with such permission, he can file. That is the difference. Sub-rule 3 of Order 23 is compromise between the parties. So in a representative suit, no part of such suit shall be abandoned or withdrawn. And no compromise or agreement or satisfaction shall be recorded. Unless the court has given at the plaintiff's expense notice to all persons as provided sub-rule 2. The same procedure has to be followed by the court. That means a public notice, either individual notice or public notice by advertisement, shall be provided so that the people having the same interest, whether that of the plaintiff or whether that of the defendant, would know what is happening in court. So a person has filed the suit as a plaintiff in a representative capacity, is withdrawing. There may be reasons. He may be colluding, or there may be fraud, or somebody who are affected thereby having the same interest may come on record and say that there is collusion or fraud, and therefore he is not prosecuting the suit with due diligence. I may be permitted to prosecute the suit. The court will permit it, so that the people are aware of what is happening in court. That is why this procedure of such publication again to be made when there is an attempt to abandon, withdraw, or compromise the suit under Order 23 Subrule 1 and Subrule 3. 5. Where any person suing or defending any such suit does not proceed with due diligence in the suit or defense, the court may substitute in his place any other person having the same interest in the suit. That is to protect the interest of similarly situated persons. If it is not diligently being done, it can be rectified by allowing another person having the same interest to join as the plaintiff and conduct the suit, or as a defendant and to conduct the suit accordingly. 6. A decree passed in a suit under this rule shall be binding on all persons on whose behalf or for whose benefit the suit is instituted or defended, as the case may be. So it is binding even without Order 1 Rule 8. It will be binding under explanation 6 to section 11. What is the wording of explanation 6 to section 11? Where persons litigate bona fide in respect of a public right or of a private right claimed in common for themselves and others, all persons interested in such right shall, for the purpose of this section, be deemed to claim under the person so litigated. There is a classic example of such case in Supreme Court, which is a suit against RSS, Rashtriya Swayamsevak Sangh, represented by the President, Secretary, Manager, etc. The suit was decreed up to Supreme Court. Their SLP dismissed. When it was sought to be executed, RSS raised a contention that RSS is not a registered body and it is not implemented as such. It cannot be implemented. All the persons who are members should be implemented, or there must be a representative suit. Here in that case, there was no such a representative suit, there was no such permission, there was no publication. The procedure in Order 1 Rule 8 was not followed at all, and therefore RSS contended that the decree is a nullity and not binding on RSS. It cannot be executed. It came to Supreme Court ultimately. Supreme Court said that these persons named therein, who are office bearers of RSS, conducted the suit diligently up to Supreme Court, and they were representing the interest of all the members of RSS, and therefore it is binding on RSS. Explanation 6 to section 11 was applied. There is some disturbance.
I'm just checking it out. You can continue. You can continue, sir. I will just.
Yes. So it was held by the Supreme Court that is binding on RSS, and it cannot be said that the suit is a decree is a nullity. And that is a connection between Order 1 Rule 8 and explanation 6 to section 11. And that was decided, that point was decided recently in Ayodhya case. I will cite all those decisions. So a decree passed in is binding. Then a question arises. A suit is decreed. Suit filed by the plaintiff in his individual capacity or as a representative capacity, whatever it is. A suit was filed against the defendants in a representative capacity. Not only the EO nominee parties as defendants, but it will be binding on all persons having the same interest, a large body of persons having the same interest as that of the defendants. And somebody violates it, who was not an EO nominee party, the decree is violated, whether he can be punished. It is a vexed question, and there are conflicting decisions. Ultimately, it came to the finding that only the EO nominee parties can be punished for violation. Only those persons who are named there or who come on record with the permission can be punished, not others. It is binding on all of them, but whether there is any willful disobedience or willful violation, it will not come under that category. And that is the latest view on that point. I will cite those decisions. Also, in recently in 2021, A Kerala High Court full bench is also there.
स्पीकर बंद किए हैं लेकिन लाइव कटे कैसे?
Then explanation. For the purpose of determining whether the persons who sue or are sued or defended have the same interest in one suit, it is not necessary to establish that such persons have the same cause of action, be it as the persons on whose behalf or for whose benefit they sue or are sued or defend the suit, as the case. We said about having common interest, having the same interest as that of others, whether as plaintiff or as defendants. A person instituting a suit in a representative capacity, several persons having the same interest, and the plaintiff suing in a representative character, or the defendant being sued in a representative character, not only representing himself but representing the whole body of persons who are having the same interest. And the decree passed therein will be binding on all, whether as plaintiffs and their binding persons, or defendants and the persons who are bound by the decree. All are bound by the decree. Exception is that violation of decree, willful violation of injunction. There is a different category, and therefore it has to be dealt with separately. It is binding on all. That does not mean that all of them must have the same cause of action. Cause of action may be different. Question is whether they are having the same interest. Cause of action may be different. See, I am filing a suit. I am a beneficiary of the village pathway. Somebody is encroaching upon. My cause of action arose in a particular manner. Somebody else encroaches upon, which affects my neighbor. He files a suit. His cause of action is different, but the subject matter is the same. Interest having, both persons having the same interest. That is the criterion to be followed. Now, this is in short Order 1 Rule 8. And the procedure has to be followed. And even if Order 1 Rule 8 is not adhered to, even if a suit is not filed under Order 1 Rule 8, even then, in some cases, it may bind not only the plaintiffs, but persons having the same interest, provided the suit was filed in that capacity representing all of them, though not under Order 1 Rule 8. But they ventilated, a plaintiff A files a suit. Now, he ventilating not only his grievance, not only his right, but also of several other persons' right having the same interest in the subject matter. And a suit is diligently prosecuted, no collusion, no fraud, no vitiating circumstances, then sometimes it will be binding, as held in RSS case by the Supreme Court, that it will be binding not only on the named persons, but also persons having the same interest in the subject matter. That is what is contained in section 11, explanation 6. So both are not contradictory to each other. They apply in different situations. And even if a suit is not filed under Order 1 Rule 8, that is not a final word to say that it is not binding on all persons having the same interest. There may be cases coming under explanation 6 to section 11, in which case the whole body of persons also may be bound by the decree that is passed by the court. And this question was considered in Ayodhya case. Ayodhya case, Siddiq M through Ellas. Siddiq M through Ellas versus Mahant Suresh Das and others. 2020 SCC 1. It was held that it is only when the parties are numerous that a suit can be brought under the provisions of Order 1 Rule 8. That is possible for a suit to be a representative suit within the meaning of explanation 6 to section 11, although it need not come under Order 1 Rule 8, and therefore need not be brought under the provisions of that order. Sometimes explanation 6 to section 11 would also do the same purpose. Explanation 6 to section 11, therefore, is not confined to cases covered by Order 1 Rule 8, but would include any litigation in which Apart from the rule altogether, parties are entitled to represent interested persons other than themselves, relying on an AER 1937 Bombay 238 decision. AER 1937 Bombay 238. Guru Siddhappa, Guru Basappa. Guru Siddhappa, Guru Basappa versus Guru Siddhappa, Chennaveerappa. So this is in Ayodhya case. Then the other decisions are, because of paucity of time, I will cite the decisions. I may not explain the whole thing. I will just cite it and give the name of the case and the citation. 2017 8 SCC. 17 8 SCC. 830. SNDP Shakha Yogam versus Kerala Atma Vidya.
So 1 minute. Mr. Sharon, just make me the host. Inadvertently, you have been made the host. Right, sir.
Versus Kerala Atma Vidya Sangham and others. What is that the court has to decide while granting permission to file the suit in a representative capacity? That is decided there. Next is 2011 4 SCC 374. Bharat Sanchar Nigam Limited versus Ghanshyam Das and others. Ghanshyam Das and others. A 3-judge bench decision. Justice R.V. Ravindran, Justice Sadasivam, and Justice A.K. Patnaik. Judgment by Justice A.K. Patnaik. Specifically, fact was also considered relief to non-applicant circumstances which envisaged. It is not necessary, following K.I. Shepherd case, it is not necessary for every person to approach the court for relief, and it is the duty or authority to extend the benefit of a concluded decision in all similar cases without driving every affected person to court to seek the relief would apply. Here, it is not, it is repetition. The question was, in a given case, the court gave a verdict, judgment. Whether similarly situated persons can have the benefit of that judgment is the question. And the Supreme Court uses the expression the fence sitters cannot be benefited. A large body of persons in service having the same interest. They did not come forward, they did not file a petition, they did not join the petition, it is not in a representative capacity. So, in what circumstances they can make use of it is the question. Next is AER 2011 Supreme Court 952. Parallel citation 2011 to SCC 11 to SCC 682. Hari Ram versus Jyoti Prasad and another. That is encroachment on public street. Any member of the community may successfully bring a suit to assert his right in the community property. In such suit, he need not comply with the requirements of Order 128. Suppose personally he has got a right. He can ventilate that right. He can have redress of the grievance without representing all other body of persons having the same interest. It is not necessary. He can do it also. The said submission is also found to be without any merit. What is the submission? That the suit is not brought in a representative capacity. In appeal, such a contention is raised. The said submission is also found to be without any merit, as apart from being a representative suit, the suit was filed by an aggrieved person whose right to use the public street of 10 feet width was prejudicially affected. Since affected person himself has filed a suit, therefore, the suit cannot be dismissed on the ground of alleged non-compliance of the provisions of Order 128. It is his preference. He may do it. Or After the 1976 amendment, the court may direct the party. Any member of a community may successfully bring a suit to assert his right in the community property or for protecting such property by seeking removal of encroachment therefrom, and that in such a suit he need not comply with the requirements of Order 128 CPC. It was further held that in the case that the suit against the alleged trespass, even if it was not a representative suit on behalf of the community, could be a suit of this kind. Next is 2000 Volume 10 SCC. 2000 Volume 10 SCC 644. Gram Panchayat of village. Next word, I will say the spelling. MUNDHAL. Next word, KHURD versus Amar Singh. Question was, in a suit filed in a representative capacity, some of the persons either joined or some of them originally was there or some of them got on record as impleaded, and some of them died during the pendency suit. Their legal representatives were not impleaded. What will happen if a person dies as a plaintiff or as a defendant is provided in Order 22. Order 22 rules 2, 3, 4 provide for the different situations where impleading is necessary. Where impleading is not made within the time provided as under Article 120 of the Limitation Act, the suit would abate. Then the abatement can be set aside under Article 121, that is within the period provided in Article 121 under Order 22 itself, and it should be done, it should be applied for within 60 days. Thereafter, there is delay. Delay can be condoned by the court under Section 5 of the Limitation Act. That is a procedure in Order 22. In a particular case where the representative suit, some of the parties died, and their legal representatives were not impleaded at all, and a decree is passed. Whether the decree is a nullity or whether the decree can be set aside on that ground, that was the question which was considered by the Supreme Court in this case. It was held that it will not abate because it is a representative suit. It does not abate upon the death of one of the plaintiffs. Important paragraph 4. It has been claimed by the appellant Gram Panchayat that the suit stood abated before the High Court in as much as 2 out of 3 plaintiffs had expired and no steps had been taken to bring on record their legal representatives. Here before us, those legal representatives have on permission been arrayed and joined as parties in the appeal. That is not enough, but subject to legal objection. It has been maintained on behalf of the appellant that on the death of those 2 plaintiffs, appellant before the High Court, the appeal thereat abated, and on that basis it claimed that the judgment and order of the High Court be upset. We are not impressed by this argument. The nature of the suit is the determining factor. The suit was filed by the plaintiffs not only for themselves but as the representatives of the proprietary community owing those lands. Their shares were undefined, and thus the suit could in any event be pursued by other co-sharers. Instantly, one plaintiff survived and was there to prosecute and now to defend the common interest at the present stage of the litigation. No occasion would thus arise of an inconsistent decrees being passed, and therefore there is no such abatement. The contention of the appellant was overruled. Next is AER 1996 Supreme Court 1211. Parallel citation 1996 3 SCC 149. K. Ramaswamy, I am sorry, that is Judge Singhai Lal Chand Jain, Singhai Lal Chand Jain versus Rashtriya Swayam Sevak Sangh and others. This is the case which I said as a prelude. Explanation 6. Procedure is the handmaid to substantive justice. The suit was laid against the Sangh represented by the manager Mr. So-and-so, the president so-and-so, a practicing advocate who is a member, no other than headmaster of the school. 3 of them had jointly filed the return statement and then contested the suit with all diligence, due diligence, and the suit was decreed for eviction. It is in that case the RSS in execution contended that the decree is a nullity. The Supreme Court negatived that contention. Read paragraph and discussion in paragraph 8, 9, 10, 11. All the relevant decisions have been referred to. 12, 13. Yes. Please see the distinction between two cases, Ayodhya case as well as RSS case. Distinction between Order 1 Rule 8 and Explanation 6 to Section 11. And the combined effect of it. Sometimes even without a representative suit, the result will be having the same, the suit, the decree, nature of the decree would be having the same result. That is because of the application of Explanation 6 to Section 11. Both are different, but at the same time, though they operate in different fields, it is not mutually exclusive, it is not contradictory. Next is 1991 3 SCC 114, Suraya Begum and another versus Muhammad Usman. There, an eviction suit was filed after the death of the original tenant against the legal representatives, but one of them was omitted to be made a party. Whether the decree is invalid, decree is void, is the question which was considered. There, the court considered in paragraph 8, paragraph 9, the principle of substantial representation, that the impleaded parties represent the state substantially, thereby binding not only on them, but all the person who was omitted to be impleaded. But that omission to implead was not as a result of fraud, pollution, or any other vitiating circumstance. Suppose a person dies, one of the defendants dies. The plaintiff does not know who are all the legal representatives. Suppose there are 10 legal representatives. They are working elsewhere, different countries. He collected all the necessary details. He found that there are 9 legal representatives, impleaded them. 10 was left out. And a decree was passed against those 9 persons. The 10th man at the execution stage comes forward and says, no, decree is not binding on me. I was not made a party, and therefore decree is void so far as I am concerned. There is non-impleadment. Decree cannot be executed. The court will say that your interest was substantially represented by the persons who are already on party. There is no fraud, collusion, or any other vitiating circumstances. So, though not made your nominee a party, it is binding on you as well. This is the principle of substantial representation. Please see paragraph 9. This is a long paragraph. Section 11, explanation 6 to section 11 was also considered there. What is a connection between the two? Now, AER 1990 Supreme Court, 444, parallel citation, 1989 supplemental 2 SEC 356. R. Venugopala Naidu and others. R. Venugopala Naidu and others versus Venkata Rayulu Naidu, Venkata Rayulu Naidu Charities and others from Andhra Pradesh, evidently. Suit under section 92 is a suit of a special nature for protection of public rights in public trust and charities. Binds not only the parties named in the suit, but all persons who are interested in such suit. Order 1 Rule 8 is not necessary there because of the application of section 92 itself. AER 1965 Supreme Court 11. 65 Supreme Court 11. State of AP versus Gundugola Venkata Suryanarayana Garu Garu. 2 persons jointly serving notice representatively on government. One of them alone filing a suit after the expiry of 2 months. Section 80 CPC notice was necessary because the government is a party. So 2 of them give notice. But when a suit is filed, only one filed the suit in a representative capacity. Court granting permission. Whether the suit is defective. Tell it is not defective. Paragraph 12. Then the next question considered was whether getting sanction of the authority of the persons interested in the suit is necessary for serving notice under section 80. It is not necessary. Paragraph 30. Whether a suit under Order 1 Rule 8 representing several persons, the plaintiff also having the same interest, and he is having a cause of action on his own. The person represented by him do not become plaintiffs in the suit. They are not unanimous, but it will be binding on. AER 1964 Supreme Court 107. Ahmad Adam Seth versus M.E. Makri, M-A-K-H-R-I. Suit under 92. Next is 2012 SCC. 2012 SCC. 750. Shripat Mahado Patil and others versus Chief Land and Surveyor CIDCO Limited, CIDCO Limited and others. Addition of defendants after public notice. After publication of notice, it is immediately filed. If there was enough material that the interest of the applicants could be affected and any adverse decision would cause prejudice to them, trial court has already exercised the discretion. Supreme Court refused to interfere in appeal. These are the Supreme Court decisions which I referred to. And later, in 2021, I said about one full bench decision. There are several decisions of the Kerala High Court and other high courts. It is not possible to refer to all of them, but I may refer to one full bench decision of the Kerala High Court. If you get it, there are several headings under that. If you get time and get the citation, you may read it. ILR 2021 3 Kerala. ILR 2021 3 Kerala 179. Narayanan MB and others versus Periyadan, 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 Narayan Nair and others. I am not referring to the other high court judgments of the Kerala High Court or any other high court. There are several. With this, I think we can close it. Still within time. And if you have got any doubt to be cleared, please ask. Thank you.
Please give illustrated examples of typical cases where applications under Order 1, Rule 8 can be filed.
Please repeat the question.
Give illustrated examples where applications under Order 1, Rule 8 can be filed.
Which are the examples?
Some illustrated examples.
I gave it at the inception itself. I gave it.
He joined somewhat
A
late.
pathway, persons having a common interest, or persons having common interest to graze cattle in a field. Such cases are rare now. Or take water from a well, common well, all having the same interest.
This is by Gangadhar.
Or
Could you
to have
please-
fishing from a common place, all having the same interest. Right to way, right to use a motorable way, right to have the width maintained. All suits persons having the same interest, they can file the suit not only for them, but for others also having the same interest. And it can be filed not only against the known defendants who are named as defendants, but representing those persons, those named defendants representing the whole body of persons who are having the same interest to deny the plaintiff's right. Yes.
Gangadhar, could you clarify the difference between Section 91 of CPC, public interest suit, vis-a-vis Order 1, Rule 8?
91, 91, 92, I said. "91 public nuisances and other wrongful acts affecting the public." That is, several persons having the right, one or more persons may file the suit against the public nuisance, causing public nuisance, affecting or likely to affect the public. A suit for declaration and injunction or for other relief may be appropriate, as may be appropriate in the circumstance the case may be instituted either by the Advocate General or with the leave of the court by two or more persons. They are having the capacity. This also akin to Order 1 Rule 8. Not Order 1 Rule 8 itself, a special procedure is provided for such suit. This is really the public interest litigation before the civil court. It is here in Ratlam municipality case, Justice Krishnaiah passed a judgment which was followed by the Supreme Court in several cases, that a sub-collector was given a direction to remove public nuisance. That was under 133 CRPC, though not under Section 91, but something akin to 90. Ratlam municipality is that having same nuances, but here the procedure is not required as provided there, because it is a public nuisance. Nuisance is there for me, for others also. Yes, it is a public. That is a difference. The other is private right. This is a public right. Yes.
In a suit, dispute is between two villages. A head of the village filed a suit, but not under Order 1, Rule 8, against the defendant.
Whether the decree is binding.
Yeah.
There on facts it has to be decided. Whether the village head really represented the interests of others. Just like RSS case. Whether he prosecuted the case with the due diligence. Whether there was any vitiating factors. Then the court has to decide whether explanation 6 to Section 11 will apply. Not Order 1 Rule 8. So even if Order 1 Rule 8 is not resorted to, even if no publication is made, in some cases it may affect not only himself but others. Then in one case, Section, I will give the citation. Section 21 of the Limitation Act provides that if a person is made a party, it shall be deemed to have been commenced on the date on which he is implemented. Suppose there are 5 defendants. One person is also implemented as the 6th defendant. It is a suit for declaration. 3 years is the period of limitation. At the time when the application was made, it was beyond 3 years. Whether it can be done? That answer is section 21. Effect of substituting or adding new plaintiff. Where after the institution of suit, a new plaintiff or defendant is substituted or added, the suit shall, as regards him, be deemed to have been instituted when he was so made a party. Provided that where the court is satisfied that the omission to include a new plaintiff or defendant was due to a mistake made in good faith, it may direct that the suit as regards such plaintiff or defendant shall be deemed to have been instituted on an earlier date. So normally when a person is impleaded as additional party, the suit as against him shall be deemed to have been instituted on that date, and if it is beyond the period of limitation, the suit has to go as against him. But exception is that it is due to a bona fide mistake, the court on facts it has to decide that. The court may pass an order. The Supreme Court has said that a separate order is necessary. Now, a case arose. Of course, it is Kerala decision. ILR 1983-1 Kerala 566 by 2 eminent judges, Justice Chandrasekhar Menon and Justice U.L. Bhatt, who later retired as a Chief Justice. Case was this. Some named parties were there in the suit. And later, after the suit is instituted, an application was filed to sue or being sued in a representative capacity. Some defendants were to be defend the suit in a representative capacity. Then a contention was raised. Those named defendants are not only defending the suit on their behalf, but on behalf of others also who are not named there. Therefore, those persons are to be treated as being made parties subsequent to the period of limitation, and therefore the suit is barred. That was the contention. Court did not accept that. And an author like Wordsworth, who wrote a judgment, not author, a judge, English case, that was not accepted by the Kerala. Effect of applying the provisions of Order 1, Rule 8 CPC is not to add parties to the suit. By invoking these provisions by fiction of law, it is deemed that innumerable persons are in the position of parties to the suit, although actually they are not parties. Section 21 of the Limitation Act contemplates substitution or addition of after institution of the suit. It cannot be said that by merely invoking Order 1 Rule 8, any person is substituted or added as a party. We therefore hold that Section 21 of the Limitation is not attractive. So that such a contention was also raised, that the ingenuity of the lawyers can be seen. Yes.
One person says that Section 245 of the Companies Court Act talks of a class action. It is somewhat akin to a representative suit.
I do not know that.
One says that a suit was initially filed by 2 plaintiffs, but thereafter there was a conflict of interest between the 2 plaintiffs. Can there be 2 advocates now representing one plaintiff number 1 and another representing plaintiff number 2?
Now there cannot be, the 2 plaintiffs cannot be having conflicting interests. Either the suit must be, one must be relegated, one must be substituted as a defendant. And then the fight must go on. 2 persons having conflicting interests cannot continue the suit as such.
Thank you, sir, for the insightful session. And despite the fact that we have taken the session slightly late, and it got later because of some unwarranted circumstances, be that as it may, on the YouTube, it's doing extremely well. Thank you for sharing even at the late time. And your popularity shows the fact that it is very popular. And,
Thank you, sir. Thank you very much.
and just like Shyam was saying, you actually explained the entire gamut of Order 1 Rule 8. And I am quite sure that people will understand. Shyam has also joined. I will ask Shyam to conclude.
Sir, just one doubt I was thinking. Certain defendants like society or cooperative society, etc., unless and until it is filed under Order 1 Rule 8, it's not maintainable. A doubt has been expressed. How far it is correct?
That's not correct. Society can be sued by representing the secretary or somebody. Order 1 Rule 8 is not necessary. It will be binding on them.
Correct, sir. Just so a doubt expressed. Sir, thank you very much. It is always a pleasure hearing you, and it has been a wonderful experience again. And thank you, Vikas, for inviting me for one thing and continuing with this good work. Thank you.
Thank you. Before we part for the day, night, by saying good evening, part 3 of series on appointments, etc., will be taken by Mr. P.S. Friday. So do stay connected with us at 5:30 on Friday. Thank you, everyone. Good night.